This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Anti-Federalist Papers. Anti-Federalist Papers, Section 31, Brutus, Letter 11. Read by M.L. Cohen. Cleveland, Ohio, 2007. 31 January, 1788. The nature and extent of the judicial power of the United States, proposed to be granted by this Constitution, claims our particular attention. Much has been said and written upon the subject of this new system on both sides, but I have not met with any writer who has discussed the judicial powers with any degree of accuracy. And yet it is obvious that we can form but very imperfect ideas of the manner in which this government will work, or the effect it will have in changing the internal police and mode of distributing justice at present subsisting in the respective states, without a thorough investigation of the powers of the judiciary and of the manner in which they will operate. This government is a complete system, not only for making, but for executing laws. And the courts of law, which will be constituted by it, are not only to decide upon the Constitution and the laws made in pursuance of it, but by officers subordinate to them to execute all their decisions. The real effect of this system of government will therefore be brought home to the feelings of the people through the medium of the judicial power. It is, moreover, of great importance to examine with care the nature and extent of the judicial power, because those who are to be vested with it are to be placed in a situation altogether unprecedented in a free country. They are to be rendered totally independent, both of the people and the legislature, both with respect to their offices and salaries. No errors they may commit can be corrected by any power above them, if any such powers there be, nor can they be removed from office for making ever so many erroneous adjudications. The only causes for which they can be displaced is conviction of treason, bribery, and high crimes and misdemeanors. This part of the plan is so modeled as to authorize the courts not only to carry into execution the powers expressly given, but where these are wanting or ambiguously expressed, to supply what is wanting by their own decisions. That we may be enabled to form a just opinion on this subject, I shall, in considering it, first, examine the nature and extent of the judicial powers, and second, inquire whether the courts who are to exercise them are so constituted as to afford reasonable ground of confidence that they will exercise them for the general good. With regard to the nature and extent of the judicial powers, I have to regret my want of capacity to give that full and minute explanation of them that the subject merits. To be able to do this, a man should be possessed of a degree of law knowledge far beyond what I pretend to. A number of hard words and technical phrases are used in this part of the system, about the meaning of which gentlemen learned in the law differ. Its advocates know how to avail themselves of these phrases. In a number of instances where objections are made to the powers given to the judicial, they give such an explanation to technical terms as to avoid them. Though I am not competent to give a perfect explanation of the powers granted to this department of government, I shall yet attempt to trace some of the leading features of it, from which I presume it will appear that they will operate to a total subversion of the state judiciaries, if not to the legislative authority of the states. In Article 3rd, Section 2nd, it is said, quote, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority," etc. End quote. The first article to which this power extends is, "all cases in law and equity arising under this Constitution." What latitude of construction this clause should receive, it is not easy to say. At first view, one would suppose that it meant no more than this, that the courts under the general government should exercise not only the power of courts of law, but also that of courts of equity, in the manner in which those powers are usually exercised in the different states. But this cannot be the meaning, because the next clause authorizes the courts to take cognizance of all cases in law and equity arising under the laws of the United States. This last article, I conceive, conveys as much power to the general judicial as any of the state courts possess. The cases arising under the Constitution must include such as bring into question its meaning, and will require an explanation of the nature and extent of the powers of the different departments under it. This article, therefore, vests the judicial with the power to resolve all questions that may arise on any case on the construction of the Constitution, either in law or in equity. First, they are authorized to determine all questions that may arise upon the meaning of the Constitution in law. This article vests the courts with the authority to give the Constitution a legal construction, or to explain it according to the rules laid down for construing a law. These rules give a certain degree of latitude of explanation. According to this mode of construction, the courts are to give such meaning to the Constitution as comports best with the common, and generally receive acceptation of the words in which it is expressed, regarding their ordinary and popular use, rather than their grammatical propriety. Where words are dubious, they will be explained by the context. The end of the clause will be attended to, and the words will be understood as having a view to it, and the words will not be so understood as to bear no meaning or a very absurd one. Second, the judicial are not only to decide questions arising upon the meaning of the Constitution and law, but also in equity. By this, they are empowered to explain the Constitution according to the reasoning spirit of it, without being confined to the words or letter. Quote, "From this method of interpreting laws, says Blackstone, by the reason of them, arises what we call equity," which is thus defined by Grotius, "the correction of that wherein the law, by reason of its universality, is deficient." For since in all laws all cases cannot be foreseen or expressed, it is necessary that when the decrees of the law cannot be applied to particular cases, there should be some where be a power vested of defining those circumstances, which had they been foreseen, the legislator would have expressed, and these are the cases which, according to Grotius, "lex non exact definit, sed arbitraro boni viram permitted." The same learned author observes, "that equity thus depending essentially upon each individual case, there can be no established rules and fixed principle of equity laid down, without destroying its very essence and reducing it to a positive law." From these remarks, the authority and business of the courts of law under this clause may be understood. They will give the sense of every article of the Constitution that may from time to time come before them, and in their decisions they will not confine themselves to any fixed or established rules, but will determine, according to what happens to them, the reason and spirit of the Constitution. The opinions of the Supreme Court, whatever they may be, will have the force of law, because there is no power provided in the Constitution that can correct their errors or control their adjudications. From this court there is no appeal. And I conceive the legislature themselves cannot set aside a judgment of this court, because they are authorized by the Constitution to decide in the last resort. The legislature must be controlled by the Constitution, and not the Constitution by them. They have, therefore, no more right to set aside any judgment pronounced upon the construction of the Constitution than they have to take from the President the chief command of the Army and Navy and commit it to some other person. The reason is plain. The judicial and the executive derive their authority from the same source, that the legislature do theirs, and therefore in all cases, where the Constitution does not make the one responsible to or controllable by the other, they are altogether independent of each other. The judicial power will operate to effect, in the most certain but yet silent and imperceptible manner, what is evidently the tendency of the Constitution. I mean, an entire subversion of the legislature, executive, and judicial powers of the individual states. Every adjudication of the Supreme Court on any question that may arise upon the nature and extent of the general government will affect the limits of the state jurisdiction. In proportion as the former enlarge the exercise of their powers, will that of the latter be restricted. That the judicial power of the United States will lean strongly in favor of the general government, and will give such an explanation to the Constitution as will favor an extension of its jurisdiction, is very evident from a variety of considerations. First, the Constitution itself strongly countenances such a mode of construction. Most of the articles in the system which convey powers of any considerable importance are conceived in general and indefinite terms, which are either equivocal, ambiguous, or which require long definitions to unfold the extent of their meaning. The two most important powers committed to any government, those of raising money and of raising and keeping up troops, have already been considered and shown to be unlimited by anything but the discretion of the legislature. The clause which vests the power to pass all laws which are proper and necessary, to carry the powers given into execution, it has been shown, leaves the legislature at liberty to do everything which in their judgment is best. It is said, I know, that this clause confers no power on the legislature which they would not have had without it. Though I believe this is not the fact, yet admitting it to be, it implies that the Constitution is not to receive an explanation strictly according to its letter, but more power is implied than is expressed. And this clause, if it is to be considered as explanatory of the extent of the powers given, rather than giving a new power, is to be understood as declaring that in constructing any of the articles conveying power, the spirit and intent and design of the clause should be attended to, as well as the words in their common acceptation. The Constitution gives sufficient color for adopting an equitable construction, if we consider the great end and design it professedly has in view. These appear from its preamble to be, quote, to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and posterity. End quote. The design of this system is here expressed, and it is proper to give such meaning to the various parts as will best promote the accomplishment of the end. This idea suggests itself naturally upon reading the preamble, and will countenance the court in giving the several articles such a sense as will the most effectively promote the ends of the Constitution has in view. How this manner of explaining the Constitution will operate in practice shall be the subject of future inquiry. Second, not only will the Constitution justify the courts in inclining to this mode of explaining it, but they will be interested in using this latitude of interpretation. Every body of men invested with office are tenacious of power. They feel interested, and hence it has become a kind of maxim to hand down their offices with all its rights and privileges unimpaired to their successors. The same principle will influence them to extend their power and increase their rights. This of itself will operate strongly upon the courts to give such a meaning to the Constitution in all cases where it can possibly be done as will enlarge the sphere of their own authority. Every extension of the power of the general legislature as well as the judicial powers will increase the powers of the courts, and the dignity and importance of the judges will be in proportion to the extent and magnitude of the powers they exercise. I add, it is highly probable that the emolument of the judges will be increased, with the increase of the business they will have to transact and its importance. From these considerations, the judges will be interested to extend the powers of the courts, and to construe the Constitution as much as possible in such a way as to favor it, and that they will do that appears probable. Third, because they will have precedent to plead to justify them in it. It is well known that the courts of England have by their own authority extended their jurisdiction far beyond the limits set them in their original institution and by the laws of the land. The Court of Exchequer is a remarkable instance of this. It was originally intended principally to recover the king's debts and to order the revenues of the crown. It had a common law jurisdiction, which was established merely for the benefit of the king's accomplishments. We learn from Blackstone that the proceedings in this court are grounded on a writ called quo minus, in which a plaintiff suggests that he is the king's farmer or debtor, and the defendant hath done him the damage complained of, by which he is less able to pay the king. These suits, by the statute of Rutland, are expressly directed to be confined to such matters as specially concern the king or his ministers in the exchequer. And by the articuli supercartus, it is enacted that no common pleas be thenceforth held in the exchequer contrary to the form of the Great Charter. But now any person may sue in the exchequer, the surmise of being debtor to the king being matter of form, and mere words of course, and the court is open to all the nation. When the courts will have a precedent before them of a court which extended its jurisdiction in opposition to an act of legislature, is it not to be expected that they will extend theirs, especially when there is nothing in the Constitution expressly against it, and they are authorized to construe its meaning and are not under any control? This power in the judicial will enable them to mold the government into almost any shape they please. The manner in which this may be effected we will hereafter examine. Brutus. End Anti-Federalist Papers, Section 31, Brutus, Letter 11. LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Anti-Federalist Papers, Section 32, Brutus Letter 12. Read by M.L. Cohen, Cleveland, Ohio, May 2007. 7 February 1788. In my last, I showed that the judicial power of the United States under the first clause of the second section of Article 8 would be authorized to explain the Constitution not only according to its letter, but according to its spirit and intention. And having this power, they would strongly incline to give it such a construction as to extend the powers of the general government as much as possible, to the diminution, and finally to the destruction, of that of the respective states. I shall now proceed to show how this power will operate in its exercise to effect these purposes. In order to perceive the extent of its influence, I shall consider, first, how it will tend to extend the legislative authority; second, in what manner it will increase the jurisdiction of the courts; and third, the way in which it will diminish and destroy both the legislative and judicial authority of the United States. First, let us inquire how the judicial power will effect an extension of the legislative authority. Perhaps the judicial power will not be able, by direct and positive decrees, ever to direct the legislature, because it is not easy to conceive how a question can be brought before them in a course of legal discussion in which they can give a decision declaring that the legislature have certain powers which they have not exercised, and which, in consequence of the determination of the judges, they will be bound to exercise. But it is easy to see that in their adjudications they may establish certain principles which, being received by the legislature, will enlarge the sphere of their power beyond all bounds. It is to be observed that the Supreme Court has the power, in the last resort, to determine all questions that may arise in the course of legal discussion on the meaning and construction of the Constitution. This power they will hold under the Constitution and independent of the legislature. The latter can no more deprive the former of this right than either of them or both of them together can take from the President, with the advice of the Senate, the power of making treaties or appointing ambassadors. In determining these questions, the court must and will assume certain principles from which they will reason, in forming their decisions. These principles, whatever they may be, when they become fixed by a course of decisions, will be adopted by the legislature and will be rule by which they will explain their own powers. This appears evident from this consideration, that if the legislature pass laws, which, in the judgment of the court, they are not authorized to do by the Constitution, the court will not take notice of them, for it will not be denied that the Constitution is the highest or supreme law, and the courts are vested with the supreme and uncontrollable power to determine in all cases that come before them what the Constitution means. They cannot, therefore, execute a law which in their judgment opposes the Constitution, unless we can suppose they can make a superior law give way to an inferior. The legislature, therefore, will not go over the limits by which the courts may adjudge they are confined, and there is little room to doubt but they will come up to those bounds as often as occasion and opportunity may offer, and they may judge it proper to do it. For as on the one hand they will not readily pass laws which they know the courts will not execute, so on the other, we may be sure, they will not scruple to pass such as they know they will give effect, as often as they may judge it proper. From these observations it appears that the judgment of the judicial on the Constitution will become the rule to guide the legislature in their construction of their powers. What the principles are which the courts will adopt it is impossible for us to say, but taking up the powers as I have explained them in my last number, which they will possess under this clause, it is not difficult to see that they may and probably will be very liberal ones. We have seen that they will be authorized to give the Constitution a construction according to its spirit and reason, and not to confine themselves to its letter. To discover the spirit of the Constitution, it is of first importance to attend to the principal ends and designs it has in view. These are expressed in the preamble, in the following words, that is, quote, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution," etc. If the end of the government is to be learned from these words, which are clearly designed to declare it, it is obvious that it has in view every object which is embraced by any government. The preservation of internal peace, the due administration of justice, and to provide for the defense of the community seem to include all the objects of government, but if they do not, they are certainly comprehended in the words, quote, "to provide for the general welfare," If it be further considered that this Constitution, if it is ratified, will not be a compact entered into by states in their corporate capacities, but an agreement of the people of the United States as one great body politic, no doubt can remain but that the great end of the Constitution, if it is to be collected from the preamble, in which its ends is declared, is to constitute a government which is to extend to every case for which any government is instituted, whether external or internal. The courts, therefore, will establish this as a principle in expounding the Constitution, and will give every part of it such an explanation as will give latitude to every department under it to take cognizance of every matter, not only that affects the general national concerns of the Union, but also of such as relate to the administration of private justice, and to regulate the internal and local affairs of the different parts. Such a rule of exposition is not only consistent with the general spirit of the preamble, but it will stand confirmed by considering more minutely the different clauses of it. The first object declared to be in view is, quote, "to form a perfect union," It is to be observed, and it is not a union of the states or bodies corporate. Had this been the case, the existence of the state governments might have been secured. But it is a union of the people of the United States considered as one body, who are to ratify this Constitution if it is adopted. Now, to make a union of this kind perfect, it is necessary to abolish all inferior governments, and to give the general one complete legislative, executive, and judicial powers to every purpose. The courts, therefore, will establish it as a rule in explaining the Constitution to give it such construction as will best tend to perfect the Union, or take from the state governments every power of either making or executing laws. The second object is "to establish justice." This must include not only the idea of instituting the rule of justice, or of making laws which shall be the measure of rule of right, but also of providing for the application of this rule, or of administering justice under it. And under this the courts will in their decisions extend the power of the government to all cases they possibly can, or otherwise they will be restricted in doing what appears to be the intent of the Constitution. They should do, to wit, pass laws and provide for the execution of them, for the general distribution of justice between man and man. Another end declare it is "to ensure domestic tranquility." This comprehends a provision against all private breaches of the peace, as well as against all public commotions or general insurrections. And to attain the object of this clause fully, the government must exercise the power of passing laws on these subjects, as well as of appointing magistrates with authority to execute them. And the courts will adopt these ideas in their expositions. I might proceed to the other clause in the preamble, and it would appear by consideration of all of them separately, as it does in taking them together, that if the spirit of this system is to be known from its declared end and design in the preamble, its spirit is to subvert and abolish all powers of the state government, and to embrace every object to which any government extends. As it sets out in the preamble with this declared intention, so it proceeds in the different parts with the same idea. Any person who will peruse the 8th section with attention, in which most of the powers are enumerated, will perceive that they either expressly, or by implication, extend to almost everything about which any legislative power can be employed. But if this equitable mode of construction is applied to this part of the Constitution, nothing can stand before it. This will certainly give the first clause in that article a construction which I confess I think the most natural and grammatical one, to authorize Congress to do anything which in their judgment will tend to provide for the general welfare, and this amounts to the same thing as general and unlimited power of legislation in all cases. To be continued. 14 February 1788. Continued from last Thursday's paper. This same manner of explaining the Constitution will fix a meaning, and a very important one too, to the 18th clause of the same section, which authorizes Congress to make laws which shall be proper and necessary for carrying into effect the foregoing powers, etc. A voluminous writer in favor of this system has taken great pains to convince the public that this clause means nothing, for that the same powers expressed in this are implied in other parts of the Constitution. Perhaps it is so, but still, this will undoubtedly be an excellent auxiliary to assist the courts to discover the spirit and reason of the Constitution, and when applied to any and every other clauses granting power, will operate powerfully in extracting the spirit from them. I might instance a number of clauses in the Constitution, which, if explained in an equitable manner, would extend the powers of the government to every case, and reduce the state legislatures to nothing. But I should draw out my remarks to an undue length, and I presume enough has been said to show that the courts have sufficient ground in the exercise of this power to determine that the legislature have no bounds set to them by this Constitution, by any supposed right of the legislatures of the representative states may have to regulate any of their local concerns. I proceed second to inquire in what manner this power will increase the jurisdiction of the courts. I would here observe that the judicial power extends expressly to all civil cases that may arise save such as between citizens of the same state, with this exception to those of that description, that the judicial of the United States have cognizance of cases between citizens of the same state claiming land under grants of different states. Nothing more therefore is necessary to give the courts of law under this Constitution complete jurisdiction of all civil causes, but to comprehend cases between citizens of the same state not included in the foregoing exception. I presume there will be no difficulty in accomplishing this. Nothing more is necessary than to set forth in the process that the party who brings the suit is a citizen of a different state from the one against whom the suit be brought, and there can be little doubt but that the court will take cognizance of the matter, and if they do, who is to restrain them? Indeed, I will freely confess that it is my decided opinion that the courts ought to take cognizance of such causes under the powers of the Constitution, for one of the great ends of the Constitution is "to establish justice." This supposes that this cannot be done under the existing governments of the states, and there is certainly as good reason why individuals living in the same state should have justice as those who live in different states. Moreover, the Constitution expressly declares that "the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states." It will therefore be no fiction for a citizen of one state to set forth in a suit that he is a citizen of another, for he that is entitled to all the privileges and immunities of a country is a citizen of that country. And in truth, the citizen of one state will, under this Constitution, be a citizen of every state. But supposing that the party who alleges that he is a citizen of another state has recourse to fiction in bringing in a suit, it is well known that the courts have high authority to plead to justify them in suffering actions to be brought before them by such fictions. In my last number, I stated that the Court of Exchequer tried all cases in virtue of such a fiction. The Court of King's Bench in England extended their jurisdiction in the same way. Originally, this court held pleas in civil cases, only of trespass and other injuries alleged to be committed vi et armis. They might likewise, says Blackstone, upon the division of the Aula Regia, have originally held pleas of any other civil action whatsoever, except in real actions, which are now very seldom in use, provided the defendant was an officer of the court, or in the custody of the marshal or prison keeping of the court for breach of the peace, etc. In process of time, by a fiction, this court began to hold pleas of any personal action whatsoever, it being surmised that the defendant has been arrested for supposed trespass that "he has never committed," and being thus in the custody of the marshal of the court, the plaintiff is at liberty to proceed against him for any other personal injury, which surmise of being in the marshal's custody the defendant is not at liberty to dispute. By a much less fiction may the pleas of the courts of the United States extend to cases between citizens of the same state. I shall add no more on this head, but proceed briefly to remark in what way this power will diminish and destroy both the legislative and judicial authority of the states. It is obvious that these courts will have authority to decide upon the validity of the laws of any of the states in all cases where they come in question before them. Where the Constitution gives the general government exclusive jurisdiction, they will adjudge all laws made by the states in such cases void ab initio. Where the Constitution gives them concurrent jurisdiction, the laws of the United States must prevail, because they are the supreme law. In such cases, therefore, the law of the state legislatures must be repealed, restricted, or so construed as to give full effect to the laws of the Union on the same subject. From these remarks it is easy to see that in proportion as the general government acquires power and jurisdiction by the liberal construction which the judges may give to the Constitution, will those of the states lose its rights until they become so trifling and unimportant as not to be worth having. I am much mistaken if this system will not operate to effect this with as much celerity as those who have the administration of it will think prudent to suffer it. The remaining objections to the judicial power shall be considered in a future paper. Brutus. End of Anti-Federalist Papers, Section 32, Brutus Letter 12. Anti-Federalist Papers, Section 33, Brutus Letter 13. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by M. L. Cohen, Cleveland, Ohio, May 2007. 21 February 1788. Having in the two preceding numbers examined the nature and tendency of the judicial power as it respects the explanation of the Constitution, I now proceed to the consideration of the other matters of which it has cognizance. The next paragraph extends its authority to all cases in law and equity arising under the laws of the United States. This power, as I understand it, is a proper one. The proper province of the judicial power in any government is, as I conceive, to declare what is the law of the land, to explain and enforce those laws, which is the supreme power a legislature may pass, but not to declare what the powers of the legislature are. I suppose the cases in equity under the laws must be so construed as to give the Supreme Court not only a legal, but equitable jurisdiction of cases which may be brought before them, or in other words, so as to give them not only the powers which are now exercised by our courts of law, but those also which are now exercised by our court of chancery. If this be the meaning, I have no other objection to the power than what arises from the undue extension of the legislative power. For I conceive that the judicial powers should be commensurate with the legislative, or in other words, the Supreme Court should have authority to determine questions arising under the laws of the Union. The next paragraph, which gives the power to decide the law and equity on all cases arising under treaties, is unintelligible to me. I can readily comprehend what is meant by deciding a case under a treaty. For as treaties will be the law of the land, every person who has rights or privileges secured by treaty will have aids of courts of law in recovering them. But I do not understand what is meant by equity arising under a treaty. I presume every right which can be claimed under a treaty must be claimed by virtue of some article or clause contained in it, which gives the right in plain and obvious words, or at least I conceive that the rules for explaining treaties are so well ascertained that there is no need of having recourse to an equitable construction. If under this power the courts are to explain treaties according to what they conceive are their spirit, which is nothing less than a power given them whatever extension they may judge proper, it is a dangerous and improper power. The cases affecting ambassadors, public ministers and consuls, of admiralty and maritime jurisdiction, controversies to which the United States are a party, and controversies between states, it is proper should be under the cognizance of the courts of the Union, because none but the general government can or ought to pass laws on their subject. But I conceive the clause which extends the power of the judicial to controversy arising between a state and the citizens of another state improper in itself, and will, in its exercise, prove most pernicious and destructive. It is improper because it subjects the state to answer in a court of law to the suit of an individual. This is humiliating and degrading to a government, and what I believe the supreme authority of no state ever submitted to. The states are now subject to no such actions. All contracts entered into by individuals with states were made upon the faith and credit of the states, and the individuals never had in contemplation any compulsory mode of obliging the government to fulfill its engagements. The evil consequences that will flow from the exercise of this power will best appear by tracing it in its operation. The Constitution does not direct the mode in which an individual shall commence a suit against a state or the manner in which the judgment of the court shall be carried into execution, but it gives the legislature full power to pass all laws which shall be proper and necessary for the purpose. And they certainly must make provision for these purposes, or otherwise the power of the judicial will be nugatory. For to what purpose will the power of the judicial be, if they have no mode in which they can call the parties before them? Or, of what use will it be to call the parties to answer, if after they have given judgment there is no authority to execute the judgment? We must therefore conclude that the legislature will pass laws which will be effectual in this head. An individual of one state will then have a legal remedy against the state for any demand he may have against the state to which he does not belong. Every state in the Union is largely indebted to individuals. For the payment of these debts they have been given notes payable to the bearer. At least this is the case in this state. Whenever a citizen of another state becomes possessed of one of these notes, he may commence an action in the Supreme Court of the general government, and I cannot see any way in which he can be prevented from recovering. It is easy to see that when this once happens, the notes of the state will pass rapidly from the hands of the citizens of the state to those of other states. And when the citizens of other states possess them, they may bring suits against the state for them, and by this means judgments and executions may be obtained against the state for the whole amount of the state debt. It is certain the state, with the utmost exertions it can make, will not be able to discharge the debt she owes under a considerable number of years. Perhaps with the best management it will require 20 or 30 years to discharge it. This new system will protract the time in which the ability of the state will enable them to pay off their debt, because all the funds of the state will be transferred to the general government, except those which arise from internal taxes. The situation of the states will be deplorable. By this system, they will surrender to the general government all the means of raising money, and, at the same time, will subject themselves to suits at law for the recovery of the debts they have contracted in effecting the revolution. The debts of the individual states will amount to a sum exceeding the domestic debt of the United States. These will be left upon them, with power in the judicial of the general government to enforce their payment, while the general government will possess an exclusive command of the most productive funds from which the states can derive money, and a command of every other source of revenue paramount to the authority of any state. It may be said that the apprehension that the judicial power will operate in this manner is merely visionary, for that the legislature will never pass laws that will work these effects, or, if they were disposed to do it, they cannot provide for levying an execution on a state, for where will the officer find property whereon to levy? To this I would reply, if this is a power which will not or cannot be executed, it was useless and unwise to grant it to the judicial. For what purpose is a power given which it is imprudent or impossible to exercise? If it be improper for a government to exercise a power, it is improper that they should be vested with it, and it is unwise to authorize a government to do what they cannot effect. As to the idea that the legislature cannot provide for levying an execution on a state, I believe it is not well founded. I presume the last paragraph of the 8th section of Article 1 gives the Congress express power to pass any laws they may judge proper and necessary for carrying into execution the power vested in the judicial department. And they must exercise this power, or otherwise the courts of justice will not be able to carry into effect the authorities with which they are invested. For the Constitution does not direct the mode in which the courts are to proceed, to bring parties before them, to try causes, or to carry the judgment of the courts into execution. Unless they are pointed out by law, how are these to proceed in any of the cases of which they have cognizance? They have the same authority to establish regulations in respect to these matters, where a state is a party, as where an individual is a party. The only difficulty is, on whom shall process be served, when a state is a party, and how shall execution be levied? With regard to the first, the way is easy. Either the executive or legislative of the state may be notified, and upon proof being made of the services of the notice, the court may proceed to a hearing of the cause. Execution may be levied on any property of the state, either real or personal. The treasury may be seized by the officers of the general government, or any lands the property of the state may be made the subject and seizure and sale to satisfy any judgment against it. Whether the estate of any individual citizen may not be made answerable for the discharge of judgments against the state may be worth consideration. In some corporations this is the case. If the power of the judicial under this clause will extend to the cases above stated, it will, if executed, produce the utmost confusion, and in its progress will crush the states beneath its weight. And if it does not extend to these cases, I confess myself utterly at a loss to give it any meaning. For if the citizen of one state, possessed of a written obligation given in pursuance of a solemn act of the legislature, acknowledging a debt due to the bearer and promising to pay it, cannot recover in the Supreme Court, I can conceive of no case in which they can recover. And it appears to me ridiculous to provide for obtaining judgment against the state without giving the means of levying execution. Brutus. End Anti-Federalist Paper, Section 33. Anti-Federalist Papers, Section 34, Brutus, Letter 14. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Reading by M.L. Cohen, Cleveland, Ohio, June 2007. 28 February, 1788. The second paragraph of Section 2D, Article 3 is in these words, quote, "In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make." End quote. Although it is proper that the courts of the general government should have cognizance of all matters affecting ambassadors, foreign ministers, and councils, yet I question much the propriety of giving the Supreme Court original jurisdiction in all cases of this kind. Ambassadors and other public ministers claim and are entitled by the law of nations to certain privileges and exemptions both for their persons and their servants. The meanest servant of an ambassador is exempted by the law of nations from being sued for debt. Should a suit be brought against such an one by a citizen, though inadvertency or want of information, he will be subject to an action in the Supreme Court. All the officers concerned in issuing or executing a process will be liable to like actions. Thus may a citizen of a state be compelled, at great expense and inconveniency, to defend himself against the suit brought against him in the Supreme Court, for inadvertently commencing an action against the most menial servant of an ambassador for a just debt. The appellate jurisdiction granted to the Supreme Court in this paragraph has justly been considered as one of the most objectionable parts of the Constitution. Under this power, appeals may be had from the inferior courts to the Supreme in every case to which the judicial power extends, except in the few instances in which the Supreme Court will have original jurisdiction. By this article, appeals will lie to the Supreme Court in all criminal as well as civil causes. This, I know, has been disputed by some, but I presume the point will appear clear to anyone who will attend to the connection of this paragraph with the one that precedes it. In the former, all the cases to which the power of the judicial shall extend, whether civil or criminal, are enumerated. There is no criminal matter to which the judicial power of the United States will extend, but such as are included under some one of the cases specified in this section. For this section is intended to define all the cases of every description to which the power of the judicial shall reach. But in all these cases it is declared the Supreme Court shall have appellate jurisdiction, except in those which affect ambassadors, other public ministers and councils, and those in which the state shall be a party. If, then, this section extends the power of the judicial to criminal cases, it allows appeals in such cases. If the power of the judicial is not extended to criminal matters by this section, I ask, by what part of the system does it appear that they have any cognizance of them? I believe it is a new and unusual thing to allow appeals in criminal matters. It is contrary to the sense of our laws, and dangerous to the lives and liberties of the citizens. As our law now stands, a person charged with a crime has a right to a fair and impartial trial by jury of his country, and the verdict is final. If he is acquitted, no other court can call upon him to answer for the same crime. But by this system, a man may have had ever so fair a trial, have been acquitted by ever so respectable a jury of his country, and still the officer of the government who prosecutes may appeal to the Supreme Court. The whole matter may have a second hearing. By this means, persons who may have disobliged those who execute the general government may be subjected to intolerable oppression. They may be kept in long and ruinous confinement, and exposed to heavy and insupportable charges, to procure the attendance of witnesses and provide the means of their defense, at a great distance from their places of residence. I can scarcely believe that there can be a considerate citizen of the United States that will approve of this appellate jurisdiction as extending to criminal cases, if they will give themselves time for reflection. Whether the appellate jurisdiction as it respects civil matters will not prove injurious to the rights of citizens and destructive of those privileges which have ever been held sacred by Americans, and whether it will not render the administration of justice intolerably burdensome, intricate, and dilatory, will best appear when we have considered the nature and operation of this power. It has been the fate of this clause, as it has of most of those against which unanswerable objections have been offered, to be explained in different ways by the advocates and opponents of the Constitution. I confess I do not know what the advocates of the system would make it mean, for I have not been fortunate enough to see in any publication this clause taken up and considered. It is certain, however, they do not admit the explanation which those who oppose the Constitution give it, or otherwise they would not so frequently charge them with want of candor, for alleging that it takes away the trial by jury. Appeals from an inferior to a superior court, as practiced in the civil law courts, are well understood. In these courts, the judges determine both on the law and the fact, and appeals are allowed from the inferior to the superior courts on the whole merits. The superior tribunal will re-examine all the facts as well as the law, and frequently new facts will be introduced, so as many times to render the cause in the court of appeals very different from what it was in the court below. If the appellate jurisdiction of the Supreme Court be understood in the above sense, the term is perfectly intelligible. The meaning then is, that in all civil causes enumerated, the Supreme Court shall have authority to re-examine the whole merits of the case, both with respect to the facts and the law which may arise under it, without the intervention of a jury. That this is the sense of the part of the system appears to me clear from the express words of it, "In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, etc." Who are the Supreme Court? Does it not consist of the judges? And they are to have the same jurisdiction of the fact as they are to have of the law. They will therefore have the same authority to determine the fact as they will have to determine the law, and no room is left for a jury on appeals to the Supreme Court. If we understand the appellate jurisdiction in any other way, we should be left utterly at a loss to give it a meaning. The common law is a stranger to any such jurisdiction. No appeals can lie from any of our common law courts upon the merits of the case. The only way in which they can go up from an inferior to a superior tribunal is by habeas corpus before a hearing, or by certiorari or writ of error, or after they are determined in the subordinate courts. But in no case where they are carried up are the facts re-examined, but they are always taken as established in the inferior courts. Continued, 6 March 1788. It may still be insisted that this clause does not take away the trial by jury on appeals, but that this may be provided for by the legislature, under that paragraph which authorizes them to form regulations and restrictions for the court in the exercise of this power. The natural meaning of this paragraph seems to be no more than this, that Congress may declare that certain cases shall not be subject to the appellate jurisdiction, and they may point out the mode in which the court shall proceed in bringing up the causes before them, the manner of their taking evidence to establish the facts, and the methods of the court's proceeding. But I presume they cannot take from the court the right of deciding on the fact, any more than they can deprive them of the right of determining on the law, when a cause is once before them, for they have the same jurisdiction as to fact as they have as to law. But supposing the Congress may under this clause establish the trial by jury on appeals, it does not seem to me that it will render this article much less exceptionable. An appeal from one court and jury to another court and jury is a thing altogether unknown in the laws of our state and in most of the states in the Union. A practice of this kind prevails in the Eastern states. Actions are there commenced in the inferior courts, and an appeal lies from them on the whole merits to the superior courts. The consequence is well known. Very few actions are determined in the lower courts. It is rare that a case of any importance is not carried by appeal to the Supreme Court, and the jurisdiction of the inferior courts is merely nominal. This has proved so burdensome to the people in Massachusetts that it was one of the principal causes which excited the insurrection in that state in the year past. Very few sensible and moderate men in that state but what will admit that the inferior courts are almost entirely useless, and answer very little purpose save only to accumulate costs against the poor debtors who are already unable to pay their just debts. But the operation of the appellate power in the Supreme Judicial of the United States would work infinitely more mischief than any such power can do in a single state. The trouble and expense to the parties would be endless and intolerable. No man can say where the Supreme Court are to hold their sessions. The presumption is, however, that it must be at the seat of the general government. In this case, parties must travel many hundred miles, with their witnesses and lawyers, to prosecute or defend a suit. No man of middling fortune can sustain the expense of such a lawsuit, and therefore the poor and middling classes of citizens will be under the necessity of submitting to the demands of the rich and the lordly, in cases that will come under the cognizance of this court. If it be said that to prevent this oppression the Supreme Court will set in different parts of the Union, it may be replied that this would only make the oppression somewhat more tolerable, but by no means so much as to give a chance to do justice to the poor and middling classes. It is utterly impossible that the Supreme Court can move into so many different parts of the Union as to make it convenient or even tolerable to attend before them with witnesses to try causes from every part of the United States. If to avoid the expense and inconvenience of calling witnesses from great distance to give evidence before the Supreme Court, the expedient of taking the deposition of witnesses in writing should be adopted, it would not help the matter. It is of great importance in the distribution of justice that witnesses should be examined face to face, that the parties should have the fairest opportunity of cross-examining them in order to bring out the whole truth. There is something in the manner in which witness delivers his testimony which cannot be committed to paper, and which yet very frequently gives a complexion to his evidence, very different from what it would bear if committed to writing. Besides, the expense of taking written testimony would be enormous. Those who are acquainted with the costs that arise in the courts where all the evidence is taken in writing, well known that they exceed beyond all comparison those of the common law courts, where witnesses are examined viva voce. The costs accruing in courts generally advance with the grade of the court. Thus the charges attending to a suit in our common pleas is much less than those in the Supreme Court, and these are much lower than those in the Court of Chancery. Indeed, the costs in the last mentioned court are in many cases so exorbitant, and the proceedings so dilatory, that the suitor has almost well given up his demand as to prosecute his suit. We have just reason to suppose that the costs in the Supreme General Court will exceed either of our courts. The officers of the General Court will be more dignified than those of the States. The lawyers of the most ability will practice in them, and the trouble and expense of attending them will be greater. From all these considerations it appears that the expense attending suits in the Supreme Court will be so great as to put it out of the power of the poor and middling classes of citizens to contest a suit in it. From these remarks it appears that the administration of justice under the powers of the judicial will be dilatory, that it will be attended with such a heavy expense as to amount to little short of a denial of justice to the poor and middling class of people who in every government stand most in need of the protection of the law, and that the trial by jury, which has so justly been the boast of our forefathers as well as ourselves, is taken away under them. These extraordinary powers in this court are the more objectionable because there does not appear the least necessity for them in order to secure a due and impartial distribution of justice. The want of ability or integrity, or a disposition to render justice to every suitor, has not been objected against the courts of the respective States. So far as I have been informed, the courts of justice in all the States have ever been found ready to administer justice with promptitude and impartiality according to the laws of the land. It is true in some of the States paper money has been made, and the debtor authorized to discharge his debts with it at a depreciated value. In others, tender laws have been passed, obliging the creditor to receive on execution other property than money in discharge of his demand, and in several of the stated laws have been made unfavorable to the creditor and tending to render property insecure. But these evils have not happened for any defect in the judicial departments of the States. The courts, indeed, are bound to take notice of these laws, and so will the courts of the general government be under obligation to observe the laws made by the general legislature, not repugnant to the Constitution, but so far have the judicial been from giving undue latitude of construction to the laws of this kind that they have invariably strongly inclined to the other side. All the acts of our legislature, which have been charged with being of this complexion, have uniformly received the strictest construction by the judges, and have been extended to no cases but to such as came within the first letter of the law. In this way have our courts, I will not say evaded the law, but so limited in its operation as to work the least possible injustice. The same thing has taken place in Rhode Island, which has just rendered herself infamous by her tenaciously adhering to her paper money system. The judges there gave a decision in opposition to the words of the statute on this principle, that a construction according to the words of it would contradict the fundamental maxim of their laws and constitution. No pretext, therefore, can be formed from the conduct of the judicial courts which will justify giving such powers to the Supreme General Court for their decisions have been such as to give just ground of confidence in them, that they will firmly adhere to the principles of rectitude, and there is no necessity of lodging these powers in the courts in order to guard against the evils justly complained of on the subject of security of property under this Constitution. For it has provided, "that no state shall emit bills of credit, or make anything but gold and silver coin a tender for payment of debts." It is also declared that "no state shall pass any law impairing the obligation of contracts." These prohibitions give the most perfect security against those attacks upon property which I am sorry to say some of the states have but too wantonly made, by passing laws sanctioning fraud in the debtor against his creditor. For "this Constitution will be the supreme law of the land, and the judges in every state will be bound thereby, anything in the Constitution and laws of any state to the contrary notwithstanding." The courts of the respective states might therefore have been securely trusted with deciding all cases between man and man, whether citizens of the same state or of different states, or between foreigners and citizens; and indeed, for aught I see, every case that can arise under the Constitution or laws of the United States ought, in the first instance, be tried in the court of the state, except those which might arise between states, such as respect ambassadors or other public ministers, and perhaps such as call in question the claim of land under grants from different states. The state courts would be under sufficient control if writs of error were allowed from the state courts to the Supreme Court of the Union, according to the practice of the courts in England and of this state, on all cases in which the laws of the Union are concerned, and perhaps all cases in which a foreigner is a party. This method would preserve the good old way of administering justice, would bring justice to every man's door, and preserve the inestimable right of trial by jury. It would be following, as near as the circumstances will admit, to the practice of the courts in England, which is almost the only thing I would wish to copy in their government. But as this system now stands, there is to be as many inferior courts as Congress may seem fit to appoint, who are to be authorized to originate and in the first instance to try all the cases falling under the description of this article. There is no security that a trial by jury shall be had in these courts, but the trial here will soon become, as it is in Massachusetts inferior courts, mere matter of form, for an appeal may be had to the Supreme Court on the whole merits. This court is to have power to determine in law and in equity, on the law and the fact, and this court is exalted above all other power in the government, subject to no control, and so fixed as not to be removable but upon impeachment, which I shall hereafter show is much the same thing as not to be removable at all. To obviate the objections made to the judicial power, it has been said that Congress, in forming the regulations and exceptions which they are authorized to make respecting the appellate jurisdiction, will make provision against all the evils which are apprehended from this article. On this I would remark, that this way of answering the objection made to that power implies an admission that the power is in itself improper without restraint, and if so, why not restrict it in the first instance? The just way of investigating any power given to a government is to examine its operation supposing it be put in exercise. If upon enquiry it appears the power if exercised would be prejudicial, it ought not to be given. For to answer objections made to a power given to a government by saying it will never be exercised is really admitting that the power ought not to be exercised and therefore ought not to be granted. Brutus. End Anti-Federalist Papers, Section 34, Brutus, Letter 14. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Anti-Federalist Papers, Section 35, Brutus, Letter 15, read by M.L. Cohen, Cleveland, Ohio, May 2007. I said in my last number that the Supreme Court under this Constitution would be exalted above all other power in the government and subject to no control. The business of this paper will be to illustrate this and to show the danger that will result from it. I question whether the world ever saw, in any period of it, a court of justice invested with such immense powers, and yet placed in a situation so little responsible. Certain it is that in England, and in the several states where we have been taught to believe the courts of law are put upon the most prudent establishment, they are on a very different footing. The judges in England, it is true, hold their offices during their good behavior, but then their determinations are subject to correction by the House of Lords, and their power is by no means so extensive as that of the proposed Supreme Court of the Union. I believe they in no instance assume the authority to set aside an act of Parliament under the idea that it is inconsistent with their Constitution. They consider themselves bound to decide according to the existing laws of the land, and never undertake to control them by adjudging that they are inconsistent with the Constitution. Much less are they vested with the power of giving an equitable construction to the Constitution. The judges in England are under the control of the legislature, for they are bound to determine according to the laws passed by them. But the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort to determine what is the extent of the powers of the Congress. They are to give the Constitution an explanation, and there is no power above them to set aside their judgment. The framers of this Constitution appear to have followed that of the British in rendering the judges independent by granting them their offices during good behavior, without following the Constitution of England in instituting a tribunal in which their errors may be corrected, and without adverting to this, that the judicial under this system have a power which is above the legislative, and which indeed transcends any power before given to a judicial by any free government under heaven. I do not object to the judges holding their commissions during good behavior. I suppose it is a proper provision, provided they were made properly responsible. But I say, this system has followed the English government in this, while it has departed from almost every other principle of their jurisprudence, under the idea of rendering the judges independent, which in the British Constitution means no more than they hold their places during good behavior and have fixed salaries. They have made the judges independent in the fullest sense of the word. There is no power above them to control any of their decisions. There is no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. Before I proceed to illustrate the truth of these assertions, I beg liberty to make one remark. Though in my opinion the judges ought to hold their offices during good behavior, yet I think it is clear that the reasons in favor of this establishment of the judges of England do by no means apply to this country. The great reason assigned why the judges in Britain ought to be commissioned during good behavior is this, that they may be placed in a situation not to be influenced by the Crown to give such decisions as would tend to increase its powers and prerogatives. While the judges held their place at the will and pleasure of the King, on whom they depended not only for their offices but also for their salaries, they were subject to every undue influence. If the Crown wished to carry a favorite point to accomplish which the aid of the courts of law was necessary, the pleasure of the King would be signified to the judges, and it required the spirit of a martyr for the judges to determine contrary to the King's will. They were absolutely dependent upon him both for their offices and livings. The King, holding his office during life and transmitting it to his posterity as an inheritance, has much stronger inducements to increase the prerogatives of his office than those who hold their offices for stated periods, or even for life. Hence the English nation gained a great point in favor of liberty. When they obtained the appointment of judges during good behavior, they got from the Crown a concession, which deprived it of one of the most powerful engines with which it might enlarge the boundaries of the royal prerogative and encroach on the liberties of the people. But these reasons do not apply to this country. We have no hereditary monarch. Those who appoint the judges do not hold their offices for life, nor do they descend to their children. The same arguments, therefore, which will conclude in favor of the tenor of the judges' offices for good behavior, lose a considerable part of their weight when applied to the state and condition of America. But much less can it be shown that the nature of our government requires that the courts should be placed beyond all account more independent, so much so as to be above control. I have said that the judges under this system will be independent in the strict sense of the word. To prove this, I will show that there is no power above them that can control their decisions or correct their errors. There is no authority that can remove them from office for any errors or want of capacity, or lower their salaries, and in many cases, their power is superior to that of the legislature. First, there is no power above them that can correct their errors or control their decisions. The adjudications of this court are final and irreversible, for there is no court above them to which appeals can lie either in error or on the merits. In this respect, it differs from the courts in England, for there the House of Lords is the highest court, to whom appeals in error are carried from the highest of the courts of law. Second, they cannot be removed from office or suffer a diminution in their salaries for any error in judgment or want of capacity. It is expressly declared by the Constitution, quote, that they shall at stated times receive a compensation for their services, which shall not be diminished during their continuance in office, end quote. The only clause in the Constitution which provides for the removal of the judges from office is that which declares that, quote, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and convictions of treason, bribery, or other high crimes and misdemeanors, end quote. By this paragraph, civil officers, in which the judges are included, are removable only for crimes. Treason and bribery are named, and the rest are included under the general terms of high crimes and misdemeanors. Errors in judgment or want of capacity to discharge the duties of the office can never be supposed to be included in the words high crimes and misdemeanors. A man may mistake a case in giving judgment, or manifest that he is incompetent to the discharge of the duties of a judge, and yet give no evidence of corruption or want of integrity. To support the charge, it will be necessary to give in evidence some facts that will show that the judges committed the error from wicked and corrupt motives. Third, the power of this court is in many cases superior to that of the legislature. I have showed in a former paper that this court will be authorized to decide upon the meaning of the Constitution, and that not only according to the natural and obvious meaning of the words, but also according to the spirit and intention of it. In the exercise of this power, they will not be subordinate to, but above the legislature. For all the departments of this government will receive their powers, so far as they are expressed in the Constitution, from the people immediately, who are the source of power. The legislature can only exercise such powers as are given them by the Constitution. They cannot assume any of the rights annexed to the judicial, for this plain reason, that the same authority which vested the legislature with their powers vested the judicial with theirs. Both are derived from the same source, both therefore are equally valid, and the judicial hold their powers independently of the legislature, as the legislature do of the judicial. The Supreme Court then have a right, independent of the legislature, to give a construction to the Constitution and every part of it, and there is no power provided in this system to correct their construction or do it away. If, therefore, the legislature pass any laws inconsistent with this sense the judges put upon the Constitution, they will declare it void, and therefore in this respect their power is superior to that of the legislature. In England, the judges are not only subject to have their decisions set aside by the House of Lords for error, but in cases where they give an explanation to the laws or constitution of the country, contrary to the sense of Parliament, though the Parliament will not set aside the judgment of the court, yet they have authority, by a new law, to explain a former one, and by this means to prevent a reception of such decisions. But no such power is in the legislature. The judges are supreme, and no law, explanatory of the Constitution, will be binding on them. From the preceding remarks which have been made on the judicial powers proposed in this system, the policy of it may be fully developed. I have, in the course of my observations on this Constitution, affirmed and endeavored to show that it was calculated to abolish entirely the state governments, and to melt down the states into one entire government, for every purpose, as well internal and local as external and national. In this opinion, the opposers of the system have generally agreed, and this has been uniformly denied by its advocates in public. Some individuals, indeed among them, will confess that it has this tendency, and scruple not to say it is what they wish. And I will venture to predict, without the spirit of prophecy, that if it is adopted without amendments, or some such precautions as will ensure amendments immediately after its adoption, that the same gentlemen who have employed their talents and ability with such success to influence the public mind to adopt this plan, will employ the same to persuade the people that it will be for their good to abolish the state governments as useless and burdensome. Perhaps nothing could be better conceived to facilitate the abolition of the state governments than the constitution of the judicial. They will be able to extend the limits of the general government gradually and by insensible degrees, and to accommodate themselves to the temper of the people. Their decisions on the meaning of the Constitution will commonly take place in cases which arise between individuals with which the public will not be generally acquainted. One adjudication will form a precedent to the next, and this to a following one. These cases will immediately affect individuals only, so that a series of determinations will probably take place before even the people will be informed of them. In the meantime, all the art and address of those who wish for a change will be employed to make converts to their opinion. The people will be told that their state officers and state legislatures are a burden and expense without affording any solid advantage, for that all the laws passed by them might be equally well made by the general legislature. If to those who will be interested in the change be added those who will be under the influence, and such who will submit to almost any change of government, which they can be persuaded to believe will ease them of taxes, it is easy to see the party who will favor the abolition of the state governments would be far from being inconsiderable. In this situation, the general legislature might pass one law after another, extending the general and abridging the state jurisdictions, and to sanction their proceedings would have a course of decisions of the judicial, to whom the Constitution has committed the power of explaining the Constitution. If the states remonstrated, the constitutional mode of deciding upon the validity of the law is with the Supreme Court, and neither people, nor state legislatures, nor the general legislature can remove them or reverse their decrees. Had the construction of the Constitution been left with the legislature, they would have explained it at their peril. If they exceed their powers, or sought to find in the spirit of the Constitution more than was expressed in the letter, the people from whom they derive their power could remove them, and do themselves right. And indeed, I can see no other remedy that the people can have against their rulers for encroachments of this nature. A constitution is a compact of a people with their rulers. If the rulers break the compact, the people have a right and ought to remove them and do themselves justice. But in order to enable them to do this with the greater facility, those whom the people choose at stated periods should have the power in the last resort to determine the sense of the compact. If they determine contrary to the understanding of the people, an appeal will lie to the people at the period when the rulers are to be elected, and they will have it in their power to remedy the evil. But when this power is lodged in the hands of men independent of the people and of their representatives, and who are not constitutionally accountable for their opinions, no way is left to control them but with a high hand and an outstretched arm. Brutus. End of Anti-Federalist Papers, Section 35, Brutus, Letter 15.